Hello everyone, welcome to Management 413, Employment Law, here at the UAB, Collat School of Business. In this video we will be covering unions and collective bargaining using Chapter 14 of our textbook, Employment Law for Human Resource Practice. Here's an outline of the chapter. What is the concept of collective bargaining? What does the National Labor Relations Act say that we can and cannot do as we go about the process of collective bargaining or trying to establish a union that would engage in collective bargaining? What are unfair labor practices and what is the process for having a union recognized? Collective bargaining is a concept that came about in the early part of the 20th century that has as its premise that if all of the workers can come together with a representative and bargain with the employer, that the workers will have their work lives improved. Labor unions are the mechanism for bringing that collective bargaining about. The National Labor Relations Act was passed in the 1930s. It is the primary federal law that allows for employees to organize themselves to engage in collective bargaining with their employers. There is a similar law for railway and airline workers called the Railway Labor Act. And federal government employees also have protection for collective bargaining under the Civil Service Reform Act. And there are various state laws that would apply as well on a state-by-state basis. The National Labor Relations Act says that its purpose is to protect the right of employees to engage in concerted activities and to decide whether or not to form a labor union. This term, concerted activities, can be extremely important. Supervisors and management are not included in the protection to engage in concerted activities. And one example of an interpretation dispute would be whether or not nurses are supervised or are supervisors or not. The U.S. Supreme Court has weighed in on that, as you can see here. So what are the rights of employees under the National Labor Relations Act? They can engage in self-organization to try to engage in collective bargaining. They can form or attempt to form a labor organization, also known as a union. They can bargain collectively with their employer. They can go on strike. They can engage in certain other concerted activities related to all of the above in order to achieve the goal of collective bargaining or to help each other out, sometimes called mutual aid or protection. We have a simulation on this topic. The meatpacking employees who walked off the job in protest over the termination of a supervisor who had refused to fire an employee for safety violations. So what is concerted activity that is protected under the National Labor Relations Act? It has to be undertaken by employees. It has to be for mutual aid or support and not for an individual employee's benefit. Look at page 499 of the textbook for the bad haircut example. Here's a case in your book, Mass Tech Advanced Technologies, holding that an appearance on television by service technician employees was protected concerted activity under the National Labor Relations Act. The National Labor Relations Act has a concept of unfair labor practices to try to regulate the conduct of both employers and employees and unions during the process of forming a union or attempting to form a reunion. What are the prohibitions on employer conduct? They may not interfere with employees who are trying to exercise their rights under the National Labor Relations Act. They can't dominate the formation of a union. We'll be talking about that in a second. They can't discriminate against or retaliate against employees who are trying to form a union or who otherwise are engaging in their protected rights under the law, and they can't simply refuse to engage in collective bargaining. For their part, unions are also regulated. They cannot coerce employees in the exercise of their rights. They can't discriminate. Remember, this is the union here. They can't discriminate against an employee in order to achieve the union's goals. They can't refuse to engage in collective bargaining. They can't try to get support from outside parties, neutral employers, through what's called a secondary boycott. They can't charge excessive fees. They can't cause an employer to pay for work that's not performed. That's called feather bedding. And they may not picket for more than 30 days and for the purpose of obtaining union recognition. Sometimes the question arises of what exactly is a labor organization. Some employers, for example, have tried to avoid unions by creating something called an employee participation program that's designed to get employees and the employer talking about these things. That looks an awful lot like a union, and the National Labor Relations Act and other labor laws would say that's just an employer-sponsored union, and you can't have an employer dominating a union. Look at the case on page 507 of your textbook, Electromation Incorporated, where the employer created action teams. Legal claims can arise under the National Labor Relations Act during periods where individuals or unions are attempting to form a union at a particular location. There have been several attempts to form a union at the Vance Mercedes plant in Alabama. It is illegal to discriminate, as I said, under the National Labor Relations Act based on exercising your collective bargaining rights. Here are the elements of that. It comes down to whether you're engaged in protected activity, concerted activity for the benefit of all. The process of organizing a union is very highly regulated. A campaign to get a union recognized includes discussion, distribution of literature, people wearing buttons, people signing petitions. All of that is protected under the National Labor Relations Act. And if it's successful, the result may be that an election will result in which a union is recognized. What are some of the issues that arise under or in the process of a union election? Sometimes employers will ask employees about what they think of a union. That is not per se a violation of the National Labor Relations Act, but it's not a good idea to interrogate employees to make the questioning too intense. Employers, for their part, may state their own views on unionization. Employers, according to the case on page 511 of your textbook, can make predictions about what will happen if a union becomes the representative of employees, but only if the consequences that they're predicting are objectively beyond the employer's control. Employers' duties during a union organizing campaign may not discharge or discriminate against pro-union employees. They have to allow discussions. They have to allow people to wear buttons. Employers may not deny organizers the right to come in and walk around in public areas or say in the cafeteria unless that is the rule for everyone. So what that means is that you're not going to see Girl Scouts coming into the Vance plant in Vance, Alabama for Mercedes, because if they allow Girl Scouts to come in and sell cookies, then they should be allowing the United Auto Workers the right to come in as well. Look at this case in your textbook involving an employer that had terminated employees for safety rules. The employees, however, said that they had on a prior occasion been engaged in union organizing activities and that that was the real reason they were fired, and the NLRB agreed with the employees that the real reason they were fired were their union activities. There are certain procedures that have to be followed for elections. First of all, it has to be an appropriate bargaining unit. You can't, for example, try to have a union formed at a bank branch with 8 employees where there might be 1,000 other branches. The factors that are used, you can see at the bottom of the page, to determine whether or not a particular group of employees is an appropriate bargaining unit is whether uh, their skills are similar, the tasks that they perform are interrelated, uh, the pay systems are in common, the policies for human resources are common. In the case of a bank branch, that is not present because all the bank branches are usually under common management. All the bank branch employees have similar skills, so a single branch could not be an appropriate bargaining unit. The first step before an election is often to ask employees to sign authorization cards to start the process of working toward a formal election. If at least 30% of employees sign authorization cards, the process continues toward an election. In an actual election, the vote has to be by secret ballot. It is possible to decertify a union as well. The Obama administration and Democrats would like to do away with the secret ballot. They would rather just be able to pass cards around and have people check yes or no for the actual election of the union. This is what some businesses might think about that. They think that if people had to vote in public by checking a box on a card, that peer pressure from employees would cause more people to say yes to the union than would be the case if they were able to vote by secret ballot. Being represented by a union is not the same thing as being a member. For example, there are teachers in Alabama who are represented by the Alabama Education Association, but the law in Alabama is that you are not required to join the union even if you are represented by the union. You don't have to pay dues to the union even if you are represented by the union. That's because Alabama is known as a right to work state. In other states that don't have that provision in their law, you would, after a union is recognized, join the union. The National Labor Relations Act has a concept of unfair labor practices to make sure that the bargaining that does take place, the collective bargaining that does take place, is fair. There are some topics that must be bargained over, and there are other topics that are permissive, and the National Labor Relations Act has rules on that. It's inevitable that sometimes there will be an impasse and perhaps a mediator will be brought in. If you declare that you are at an impasse, the employer can say, "This is my last, best, and final offer." Look at this case in the textbook, NLRB versus White Cell, where an employer thought it was at an impasse, but the union said, "Well, we really weren't. You didn't try hard enough," and the court agreed with the union. The NLRB does give employees the right to strike. Most negotiations conclude without a strike. When you strike, that is not the same thing as quitting. You can also, in addition to striking, you can also engage in picketing. That is also protected concerted activities. Strikers cannot be fired, but they can be replaced, which can lead to some interesting situations where perhaps a job has been given away. A job can be given away if the strike is over economic matters, which is usually the case. However, if the strike is over unfair labor practices that the union or the employees think have been committed by the employer, then strikers must be reinstated. Employers also have an equivalent right. It's not called a strike, but it's called a lockout. And some of you may know that management lockouts have occurred in professional sports on occasion. If a labor union is organized and a labor agreement is reached, one of the key features of a labor agreement will be the right of employees to file grievances. The grievances are not filed by the union. The union might look at the grievance and provide advice. A grievance will usually go to arbitration, which you'll recall is an alternative form of dispute resolution. This is what a grievance log might look like. Arbitrators often will look at past grievances to see how they were decided and will follow that in the next grievance that is filed on the same topic. That is it for this set of slides. The second half of this learning module is Chapter 15, Occupational Safety and Health.